So there's been much ado about Ketanji Jackson's Dissent. And so I'm going to read Ketanji Jackson's Dissent. But I just want to make a few comments about what people are saying. You had that goddamn Megyn Kelly. They're all saying, man, that Amy Coney Barrett said that Ketanji Jackson, stupid. Tim Pool said the same shit. Essentially, she's saying that she's a dumb person. A dumb person who doesn't know the Constitution. These motherfuckers don't act like winners. I mean, I like how Jerry Rice would catch a touchdown. Instead of doing an icky shuffle like he never caught a touchdown a day in his life, he got his job done. Made a fucking touchdown. All right, go back to the bench. What's the next play? I've made a touchdown before. I don't need a goddamn motherfucking showboat, to New York City back to Sunset Boulevard. That's how I think a awesome, gracious winner would act, but a person that has never won a damn game in their life or never made a touchdown would probably be like, man, I made a touchdown, look at that. I made a touchdown, I'm the only one that made a touchdown, I'm the only one that will ever make a touchdown. And fuck all you dumb motherfuckers, you idiots! So this is Trump v. Casa or Casa. I don't know how to pronounce this. Casa Incorporated. It's some anagram that means something else. So we'll go with what? Casa or Casa? Let's go with Casa. So Trump v. Casa. Trump v. Casa, this is about the nationwide injunctions, right? It's not about birthright citizenship. What birthright citizenship? We don't give a damn about no birthright citizenship. What we care about is whether or not the district courts are actually implementing these damn permanent nationwide injunctions. If Obama wants to go around taking everybody's guns in America, he's allowed to do it, and the only people that get to keep their guns are the ones that file a federal lawsuit in federal court. Those are the only people that get to have their Second Amendment upheld. You even had Sotomayor point out Pierce v. the Society of Sisters. There was a permanent injunction, a nationwide injunction with that as well. Oregon says all the kids have to go to public schools. They were sued, and the person that sued said, what about private schools? Can I send my kid to private schools? Don't parents have a right to educate their kids the way that they want to? And so they struck that law down, that you can't just force all the kids to go to public government schools and only government schools. So getting rid of these nationwide injunctions, that's a nationwide injunction is a perfect way to attack birthright citizenship. Oh, I think I'm just going to get rid of the 14th Amendment. Why is that? Because I don't want brown people. I don't want brown babies here. But the babies were born on the soil, so that makes them American. Their parents aren't American, but the baby is an American. Nah, I don't give a damn. I don't give a damn. I'm a racist, white supremacist pile of shit. I'm a fascist, totalitarian, Nazi fuck. Who gives a fuck? Trump v. Casa. Trump v. Casa 2025. This is about not birthright citizenship, but it's about whether or not district courts are allowed to issue nationwide injunctions. Yeah, okay. So I'm just going to read it verbatim. I'm just going to read this thing verbatim, and let's see how it goes. Justice Jackson, dissenting. I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point: the court's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. Existential threat to the rule of law. No shit. So this criminal administration is threatening the very rule of law itself? It is important to recognize that the executive's bid to vanquish so-called universal injunctions is, at bottom, a request for this court's permission to engage in unlawful behavior. When the government says do not allow the lower courts to enjoin executive action universally as a remedy for unconstitutional conduct, What it is actually saying is that the executive wants to continue doing something that a court has determined violates the Constitution. Please allow this. This is some solicitation. With its ruling today, the majority largely grants the government's wish. But in my view, if this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny it. So far, this Ketanji Jackson doesn't sound like a dumb fucking dumb idiot, dumb stupid dumb motherfucker. Tim Pool, you dumb piece of shit. Goddamn Megyn Kelly, you goddamn motherfucking idiot, motherfucking dumb motherfucking low IQ stupid ass pile of shit. Stated simply, what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exceptions. Nobody's above the law. Nobody's below the law. We are all the law. In a republic, we have to bound ourselves to the law. And for that to actually happen, courts must have the power to order everyone, including the executive, to follow the law, full stop. To conclude otherwise is to endorse the creation of a zone of lawlessness within which the executive has the prerogative to take or leave the law as it wishes, and where individuals who would otherwise be entitled to the law's protection become subject to the executive's whims instead. The majority cannot deny that our Constitution was designed to split the powers of a monarch between the governing branches to protect the people. Nor is it debatable that the role of the judiciary in our constitutional scheme is to ensure fidelity to law. But these core values are strangely absent from today's decision. Focusing on inapt comparisons to impotent English tribunals, the majority ignores the judiciary's foundational duty to uphold the Constitution and laws of the United States. The majority's ruling thus not only diverges from first principles, it is also profoundly dangerous, since it gives the executive the go-ahead to sometimes wield the kind of unchecked arbitrary power the founders crafted our Constitution to eradicate. The very institution our founding charter charges with the duty to ensure universal adherence to the law now requires judges to shrug and turn their backs to intermittent lawlessness. With deep disillusionment, I dissent. I'm loving a lot of this stuff. Ketanji, was it Brown Jackson? She is speaking my language. John Adams says that we're a nation of laws, not of men. Thomas Paine said that we're a nation of laws, not of men. John Adams actually said that we're an empire of laws. Our founding documents is what makes us Americans. Abraham Lincoln said we better study our laws. We want our political institutions to carry on, then we better study our laws and learn to love our laws and to teach our laws to the next generations. To hear the majority tell it, this suit raises a mind-numbing technical query. Are universal injunctions sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act? To fall within the equitable authority, Congress granted federal courts in the Judiciary Act of 1789. But that legalese is a smoke screen. It obscures a far more basic question of enormous legal and practical significance. May a federal court in the United States of America order the executive to follow the law? Can the judicial branch order the executive branch to follow the Constitution? Of fucking course they can. If the judicial branch can't tell the executive branch to follow the fucking Constitution, then who the fuck is going to tell the executive branch to follow the fucking Constitution? Is that not the supreme law of the goddamn land? So these fucking court systems will sit there and rubber stamp a goddamn cop that beats the shit out of somebody who jaywalked. But then when it comes to somebody just saying, oh, the 14th Amendment, I'm going to wipe my ass with it. There's nothing the goddamn judiciary can do about that. Nothing that the goddamn judiciary can do about that. I like how she asked the question. They're going to defer to the High Court of Chancery, right? The majority, the High Court of Chancery, the Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. We just created a brand new country. We just created a brand new nation. The revolution was severing the ties and dissolving the goddamn political bonds that bound us to goddamn fucking Britain. Them fucking redcoats, those lobster-back motherfuckers, they want to not just tax our tea, but they had the Government Act. They were going to sit there and shut down our legislators and executives and governors, and they were going to put their own royal governors in place. Remember the Boston Tea Party, the Boston Massacre? The whole idea was to make sure that we will never have a fucking king ever again. That's why we have a bunch of elections. That's why we got a Bill of Rights. That's why we got 3 branches of government, the rule of law. And so she says when you ask the question, you answer it. Can the judicial branch of the United States of America order the executive branch to follow the law, i.e. the Constitution? Can the judicial branch tell the executive branch to follow the Constitution? Of fucking course they can. That's the whole point of judicial review. Marbury v. Madison is judicial review. The judicial branch gets to look at what the executive and the legislators are doing, and if they're not following the Constitution, then they can say, fuck you dumbass motherfuckers, follow the Constitution, you stupid fucking fucks. To ask this question is to answer. In a constitutional republic such as ours, a federal court has the power to order the executive to follow the law, and it must. It is axiomatic that the Constitution of the United States and the statutes that the people's representatives have enacted govern in our system of government. Thus, everyone from the president on down is bound by law. By duty in nature, federal courts say what the law is if there is a genuine dispute and require those who are subject to the law to conform their behavior to what the law requires. This is the essence of the rule of law. Don't take my word for it. Venerated figures in our nation's history have repeatedly emphasized that the essence of our free government is leave to live by no man's leave underneath the law, to be governed by those impersonal forces which we call law. Youngstown Sheep and Tube Company v. Sawyer, 1952. That's got to do with Harry Truman. Harry Truman wasn't allowed to do some shit, take over the mines or something for Korea. R. Jackson, J. concurrent. Our government is fashioned to fulfill this concept so far as humanly possible. Put differently, the USA has a government of laws and not of men. Thomas Paine said it. John Adams said it. Here we got Cooper v. Aaron, 1958. Frankfurter J. concurring, saying it, quoting U.S. v. Mine Workers. 1947, Frankfurter J. concurring in judgment. See also the Massachusetts Constitution, Part 1, Article 30, 1780. In the third part of federal and state constitutions, 1893, F. Thorpe edition, 1901, J. Adams, Marbury v. Madison. So that means John Adams, John Marshall, Thomas Paine. They all said we're a nation of laws, not of men. We all have a right to speak. We all have a right to petition and to peacefully assemble. It doesn't matter what goddamn monarch tries to tell us that we ain't allowed to have a grand jury right when it comes to the Fifth Amendment. The Constitution is the Constitution is the Constitution. That familiar adage is more than just mere rhetorical flourish. Cooper. It is the rejection in positive terms of rule by fiat, whether by the fiat of government or private power. Indeed, constitutionalism has one essential quality. It is a legal limitation on government. It is the antithesis of arbitrary rule. Its opposite is despotic government, the government of will instead of law. See McIlwain, Constitutionalism, Ancient and Modern. See also it at 21. All constitutional government is by definition limited government. Those who birthed our nation limited the power of government to preserve freedom. as they knew all too well, constant experience shows us that every man invested with power is apt to abuse it and to carry his authority as far as it will go. Montesquieu, The Spirit of the Laws, in 38 great books of the Western world. Montesquieu, she's quoting The Spirit of the Laws. Montesquieu, you know where Montesquieu comes from? That's the Federalist Papers. That's Alexander Hamilton. He also talks about Grotius and Puffendorf and Burlamaqui. But the founders reasoned that the vice of human ambition could be channeled to prevent the country from devolving into despotism. Ambition could be made to counter ambition. Ambition could be made to counter ambition. That's the Federalist number 51. That's the most famous Federalist paper. 51. If you're a true blue American, of course you've read Federalist 51. Number 10 is like the second one. And then they all got something in them. I remember I got made fun of in fucking college for falling asleep in class whenever they were talking about the Federalist Papers. But essentially, you got the Constitution. That's only, what, 5 to 10 pages? That's nothing. The Federalist Papers, like, delves deep into it. The Federalist Papers are a deep dive into the U.S. Constitution. If there were, say, a constitution that divided power across institutions in such a manner as that each may be a check on the other, then it could be possible to establish government by and for the people, and thus stave off autocracy. Again, that's Federalist 51. See also Myers v. U.S., 1926, Brandeis J. Dissent. The doctrine of the separation of powers was adopted by the Convention of 1787, not to promote efficiency, but to preclude the exercise of arbitrary power. Through such separated institutions, power checks power. See Montesquieu, The Spirit of the Laws. My God, if you haven't read The Spirit of the Laws and you haven't read the Federalist Papers, have you even read the Constitution? I bet you some of you goddamn Americans aren't even reading the fucking Constitution. You're not bound by any fucking laws because you're addicted to sin and you love being wicked and evil. You have no morals, you have no principles, so why the hell would you bound yourself to laws, which is morals etched in stone? Our system of institutional checks thus exists for a reason, so that the private interest of every individual may be a sentinel over the public rights. Holy fucking shit! The Federalist number 51 kicks the fucking majority's ass. The Federalist number 51 just says, read that again, everybody paying attention? The private interest of every individual may be a sentinel over the public rights. Meaning, if somebody takes away, Joe Blow's fucking right to petition and he fights the government, that private interest was a sentinel for public rights. We all have the First Amendment. We all have a right to petition, to peacefully assemble, to religion, to the press, to speak. The first, second, third, fourth, fifth. We have all of the freedoms of the Bill of Rights. We have all the freedoms in the Constitution, in the body, in the preamble, in all 27 amendments. The private interest of every individual may be a sentinel over the public rights. So in Pierce v. Society of Sisters, just like Heller, just like McDonald, just like that Ramos v. Louisiana, you have a right to a unanimous jury decision. You have a right to bear arms in defense of home, person, and property. So because one person defended the right to the Second Amendment when it comes to Heller and McDonald, that means all the rest of us have the right to the Second Amendment as well. Same thing with birthright citizenship. A permanent nationwide injunction is the perfect way to go after somebody that says, no, you don't have a right to peacefully assemble. Why not? Because you got brown skin. Oh, okay. Well, that's a dumb racist fucking way to think about things. And if you're a dumbass racist, I just read there was a killing. The 14-year-old kid was killed in South Carolina. And it turns out that it was the white fucking plantation owner They put it, the murder of these two little girls on this poor black boy, and they're going to execute this little black boy, this little tiny, 5-foot black boy, by electric chair, and it took him like 3 times to fucking do it. But it turned out it was the rich guy where they found the 2 girls' dead body. The 2 girls' dead body was found on the rich guy's fucking land. Is it like, hell, you think it was the rich guy who did it? Well, I don't know. Let's blame this black kid over here. Oh, okay, let's do that instead. So when you sit there and you're just a bunch of racist fucks, how many criminals are you allowing amongst your fucking selves? You think the ruling class, they still visit Epstein Island? You think they got a new Epstein fucking island to go to? The distribution of power between the judiciary and the executive is of particular importance to the operation of a society governed by law. Made up of free, impartial, independent judges and justices, the judiciary checks the political branches of government by explaining what the law is and securing obedience with it. Mine workers. See, Marbury too. We keep quoting Marbury v. Madison. I heard, one of the Tim Pool's people were sitting there saying, Marbury v. Madison, that's the first one. She doesn't even know the Constitution or Marbury v. Madison. Even I know Marbury v. Madison. I guarantee you, no, you do not. You do not know Marbury v. Madison. The federal courts were thus established. The main thing with Marbury v. Madison is that it established judicial review. The courts have a right to check the legislature and the executive branch to make sure that what they're doing is fucking constitutional. That's Marbury v. Madison. That's the main fucking point, the main goddamn holding. There's a mandamus, and then there's, Madison and Marbury and fucking Jefferson and midnight appointments and John Adams and the midnight judges, and then they're not going to get the appointment. So, there's a lot of details when it comes to Marbury v. Madison. But it's a brilliant decision, and there's a lot to it. I would encourage every one of you motherfuckers, Tim Pool, Megyn Kelly, why don't you read Marbury v. Madison? Tell me what you think about it. The federal courts were thus established not only to decide upon the controverted rights of the citizens as against each other, but also upon rights and controversy between them and the government, U.S. v. Lee, 1882, quite unlike a rule of kings governing system and a rule of law regime. Nearly every act of government may be challenged by an appeal to law. Cooper, opinion of Frankfurter. Let's hear that again. So in America we have a republic, right? A bunch of fucking dumb motherfuckers. But it's not a democracy, it's a republic. We're actually a republic. Okay, well you gotta have elections, which makes us the democracy. It's a democratic republic. It's also a constitutional democratic republic. But instead of having a rule of kings governing system, we have a rule of law regime. And in a republic, every act of the government may be challenged by an appeal to law. If somebody says, well, according to the law, you're not allowed to do Obamacare, you're not allowed to do gun confiscation, you're not allowed to do A, B, C, and D, you're not allowed to, what was it about Biden? Oh yeah, he's not allowed to forgive student loans. In this country, the executive does not stand above or outside of the law. Consequently, when courts are called upon to adjudicate the lawfulness of the actions of the other branches of government, the judiciary plays an essential part of the democratic process. Mine workers. Were it otherwise, were courts unable or unwilling to command the government to follow the law, they would sanction a tyranny that has no place in a country committed to well-regulated liberty and the protection of personal rights. Lee. It is law, and law alone, that saves a society from being rent by internecine strife or ruled by mere brute power, however disguised. Is it we're just a bunch of animals? Are we just dissolving into barbarity? Is that what we're doing here? It is law and law alone that saves a society from being rent by internecine strife or ruled by mere brute power, however disguised. Cooper quoting Mine Workers. The power to compel the executive to follow the law is particularly vital where the relevant law is the Constitution. When the executive transgresses an act of Congress, there's mechanisms through which Congress can assert its check against the executive unilaterally, such as, for example, asserting the power of the purse. But when the executive violates the Constitution, the only recourse is the courts, the judicial branch. If you eliminate the judicial branch, and our government ceases to be one of limited powers. Gregory v. Ashcroft, 1991. After all, a limit that does not confine the person on whom it is imposed is no limit at all. Again, she's quoting Marbury v. Madison. A limit that does not confine the person on whom it is imposed is no limit at all. With that background, we can now turn to this suit and focus on the ways in which the majority's ruling undermines our constitutional system. Justice Sotomayor has laid out the relevant facts, see ante, 9-3 dissenting opinion, and I will not repeat what she has said. It suffices for my purpose to reiterate that before these applications arrived here, 3 district courts had concluded that Executive Order number 14160, which attempts to alter the Constitution's express conferral of citizenship on all who are born in this nation, Amendment 14, Section 1, likely violates the Constitution. Those courts each thus enjoined the executive from enforcing that order anywhere against anyone. And thank God they did that. Thank God. So now she explains how anybody who's not a party to the case can now get fucked the fuck over. So if you were born in America, but Trump says fuck you and he's going to ship you to Sudan, doesn't matter. You don't have birthright citizenship. You don't have a right to birthright citizenship. You have no rights at all. If he wants to ship an American who's born on this country, born on this soil to Sudan, fuck you. He gets to do it. Whether you're Democrat, Republican, old, young, black, white. If he just wants to goddamn deport you just for the fuck of it. Because of this Trump v. Casa decision, he's allowed to do so. It holds that even assuming that Executive Order number 14160 violates the Constitution, federal courts lack the power to prevent the executive from continuing to implement that unconstitutional directive. As I understand the concern, in this clash over the respective powers of 2 coordinate branches of government, the majority sees a power grab, but not by a presumably lawless executive choosing to act in a manner that flouts the plain text of the Constitution. Instead, to the majority, the power-hungry actors are, wait for it, the district courts, admonishing district courts for daring to assert the power to order the executive to follow the law universally. In the majority's view, federal courts only have the power to afford the plaintiff complete relief in the cases brought before them, and they can do nothing more. And the majority thinks the so-called universal injunction, that is, a court order requiring the executive to follow the law across the board, not just with respect to the plaintiff, grants relief to non-parties. And the majority's sole basis for that proposition is the practice of the High Court of Chancery. High Court of Chancery? I don't even like saying it. Well, according to the High Court of Chancery, fuck you. Take your High Court of Chancery and shove it up your fucking ass, you motherfuckers. Star Chamber motherfuckers in England. But this cramped characterization of the judiciary's function is highly questionable when it comes to suits against the executive. That is, even if the majority is correct that courts in England at the time of the founding were so limited, and I have my doubts, see ante, 18-20, Sotomayor J. Why would courts in our constitutional system be limited in the same exact way as the High Court of Chancery back in 1760s? The founders of the United States of America squarely rejected a governing system in which the king ruled everybody. and all others, including the courts, were his subordinates. In our Constitution-centered system, the people are the rulers, and we have the rule of law. So it makes little sense to look to the relationship between English courts and the king for guidance on the power of our nation's judiciary vis-a-vis its executive. See the Federalist, number 69. Again, she's quoting another Federalist. Not just 51, but 69. This is Hamilton, explaining how the president differs from a king, including because the person of the King of Great Britain is sacred and inviolable. There is no constitutional tribunal to which he is amenable. So the king's above all the fucking courts and the legislator and above everybody. There's a difference between a president and a king. A king is a cheater. A king is a piece of shit. A king has no authority whatsoever, but he pretends he's got all the authority in the world. The king wants absolute and arbitrary authority. He wants all the power for everybody to do as his whims. That's where all the miseries of all human history comes from. When one fucking prick says everybody has to obey me and only me. Having universal, absolute, arbitrary power is good for that one fucking guy. It's miserable for the rest of us. The person of the King of Great Britain is sacredcy. Indeed, is precisely the only function. Put differently, the majority views the judiciary's power through an aperture that is much too small, leading it to think that the only function of our courts is to provide complete relief to private parties. Sure, federal courts do that, and they do it well. That's the only thing the federal courts are supposed to do. Provide complete relief to private parties. And then what the fuck is ICE doing? What is the FBI and the ATF doing? The only function of our courts is to provide complete relief to private parties. That's it? Sure, federal courts do that, and they do it well, but they also diligently maintain the rule of law itself. When it comes to upholding the law, federal courts ensure that all comers, everyone to whom the law applies and over whom the court has personal jurisdiction, including and perhaps especially the executive, know what the law is, and most importantly, follow it. Still, upon reading the court's opinion, the majority's foundational mistake in mischaracterizing the true scope and nature of a federal court's power might seem only marginally impactful. Indeed, one might wonder why all the fuss. After all, the majority recognizes that district courts can still issue universal injunctions in some circumstances. Well, shit. You can still do nationwide injunctions? What's the exceptions? I thought this was a fucking ban on, goddamn nationwide injunctions. But apparently we're still doing, we don't have to do Rule 23 class action. We could just do nationwide injunctions. What are the exceptions? For the billionaires? Well, for the billionaires, they're still allowed to do nationwide injunctions, but not for the American people. Birthright citizenship affects us all. There's not a single American here today that isn't American by the virtue of their birth. Some of us got naturalized in. Some of us had one or two parents or some shit like Ted Cruz. But the great, vast majority, the super majority of the 340 million Americans, we're Americans because we were born in one of these 50 nifty United States. We were born on the soil. And that's it. You take away birthright citizenship, well then, you better start doing a civics exam. Because if all you're saying is blood is all that's necessary, having one parent that was an American, that's what makes a citizen. So if an American just goes to goddamn Germany and fucks a bunch of German women or men and has a bunch of German babies, you're telling me all 20 of those German babies get to come back in here and say, hey, we're Americans. Nope, we're Americans and we get to do whatever the fuck. We get to shit on the street. Is that what our freedoms entail? We're allowed to shit on the street? So the majority recognizes that district courts can still issue universal injunctions in some cases. No one is saying that the reasoning of a district court's opinion on its own has the legal force of a judgment. Of course it does not. The real issue today's applications raise is whether district court opinions are entitled to respect while litigation over the lawfulness of the defendant's conduct is ongoing. That's as far as I've read so far, so I have to take more notes later on. But so far, this has been fucking riveting. This is such a good fucking dissent. That's what they're pissed off about. Damn it, she wrote a really good dissent. It might be like Dred Scott decision. Nobody gives a fuck about what the majority said with Dred Scott. Who was the dissenters in Dred Scott? Let's learn some. Let's learn something today. So John McLean and Benjamin Robbins Curtis are the fucking champions of the world. They dissented from the majority's decision in Dred Scott. John McLean and Benjamin Robbins Curtis. So their dissent is actually the holding, because they were talking about eternal law. And anybody who knows anything about natural law, what did Thomas Aquinas say about natural law? He said that natural law is rational man's participation in eternal law. So those are the really good Supreme Court cases. Eternal law. Those that touch upon that touchstone, that foundation of eternal law. You dig?